Okay, we're going to get started. Folks in the back, take it outside or come sit down, but we're going to start. Okay, I am tough. Remember that, yeah, when I'm moderating. Okay, good morning. How are you all feeling?
Great.
Yeah, I was afraid of that. So, but cheer up, because this is a panel about upholding our nation's promise of equal opportunity for all and the Constitution's guarantee of equal protection under the laws. And we have a terrific panel in which to do that. I'm Alan Jenkins. I'm Executive Director of the Opportunity Agenda. And I am also co-chair of the ACS project on the Constitution in the 21st century. This is a panel entitled Disparate Impact's Future, from Griggs to Ricci, and the Battle to Preserve Traditional Remedies. And as I said, I think it's at least that important, and in fact is something about the very purpose of the Equal Protection Clause and what it ought to mean in the 21st century. Before I get started, I have the usual announcements, logistical announcements. First, please turn your cell phones off or to silent mode. And you all are watching me say that, but you're not turning off your cell phones. So when your cell phone rings, you will be socially ostracized by those around you. So do it now. And the panel, please turn your cell phones entirely off, because it will screw up our audio system. Second, this session is being recorded, so audience members, when we get to the discussion section, I'm going to ask you to please use the microphone so we can capture your questions. So even if you have a loud voice, we still need you to talk into a microphone. So just wait, raise your hand, I'll select you, and then wait for the microphone before you start. And third, I'm going to apologize to the panelists as well as the audience in advance, because we have a pretty tight time frame to cover a lot of material. So I'm going to politely cut you off if you're going significantly over the time that we have to engage on a particular subject. Don't take it personally. All right. This year, 2011, marks the 40th anniversary of the Supreme Court's decision in Griggs versus Duke Power, in which the court endorsed the principle that using job criteria that are both unrelated to work performance and that disproportionately exclude applicants of a particular, in that case, race, constitutes discrimination in violation of Title VII of the Civil Rights Act of 1964. Since that time, the disparate impact standard has been broadly applied, but also frequently contested and increasingly controversial. It's been used to topple arbitrary barriers facing women entering construction and firefighting and the police departments. It's opened up neighborhoods to integrated housing and quality schools, many for the first time. It has prevented the dilution of minority votes in jurisdictions around the country. And it's addressed the overconcentration of environmental hazards, toxic hazards in communities of color. I think it's fair to say that very little of the progress that we've been able to make on those various issues could have been made without the disparate impact standard, or at least with the kind of post-Feeney, very rigorous and almost impossible to meet intent standard that the Equal Protection Clause has been more recently read to include. Many employers specific to Title VII also say that the disparate impact standard has made their hiring more professional and more accurate, more focused on actual qualifications and validated standards and less on arbitrary and subjective beliefs about what makes for a good employee, and the idea that certain people just don't fit in. And we've heard that frequently. But the Supreme Court, among others, has consistently and increasingly pushed back against its own past precedent in this area. So the court weakened the disparate impact cause of action in the 1989 Ward's Cove case, only to see Griggs largely reinstated by the Civil Rights Act of 1991. The court held in the 1983 Guardians case that the Title VI statute cannot be used to assert a disparate impact cause of action, but that agency regulations implementing Title VI, virtually all of which include a disparate impact provision, can be used in a private cause of action. And then in 2001, the court turned around in Alexander versus Sandoval and said, only kidding, actually you can't use the regulations to sue either, really removing a huge and hugely important tool, private cause of action, for enforcing the disparate impact standard. And most recently in Ricci versus DeStefano, the New Haven firefighters case, the court found that some applications of Title VII's disparate impact analysis actually constitute intentional discrimination in violation of Title VII's disparate treatment standard, if you can follow that one. And Justice Scalia, in particular, concurring in the Ricci outcome, wondered aloud whether disparate impact is consistent with equal protection. And I think we know where he was headed in the implications of that. I think it's also worth saying that support for the disparate impact cause of action in its various statutory implications in the executive branch has waxed and waned over time. And so the Reagan and Bush 41 Justice Departments literally banned the use of Griggs and disparate impact in their litigation strategies. Attorneys, line attorneys were not allowed to cite the case. And then, of course, other administrations have treated it much more favorably, and some have actually used it as a proactive tool. And we're going to hear a bit about where the Obama administration, or at least the Justice Department Civil Rights Division, is on that score. And then one final point I wanted to make before I introduce the panel is that until the mid-1970s, it was frequently, and I think probably accurately, perceived that a form of disparate impact, unjustified disparate impact, actually could constitute a violation of the Equal Protection Clause itself. And so in 1976 and 1977, when the court decided Washington versus Davis and Village of Arlington Heights, many were surprised that intent was the only way, discriminatory intent was the only way in which one could establish an equal protection violation. When the court decided Feeney and essentially stated that what intent means is not simply that you took, a state actor took an action despite of a disparate impact, but one actually has to prove that it was precisely because of that disparate impact in order to establish a 14th Amendment violation. Again, many were quite surprised. And then, of course, in McCleskey versus Kemp, we learned that overwhelming statistical evidence that the race of the victim is the predominant determinant factor on whether the death penalty will be assigned in some states like Georgia. The court decided that that was not enough to prove even an intent standard violation of the Equal Protection Clause without particularized evidence of intent and racial animus on the part of the actual decision makers. You can see how far we've come over the course of the 40 years since Griggs was decided. It's in that legal and political context that I'm especially pleased to have a terrific panel of scholars and practitioners to talk through with us what disparate impact means and what it should mean in the 21st century. And again, I'm going to apologize because they're an extremely accomplished group, and I am going to give you only as much information as you would need to pick them out of a lineup. So do look at their bios, which are very rich and in the packets. And I'm also going to just introduce them in the order in which they'll initially be speaking. But we're very intent on this being a conversation, not a lecture, and so we're going to get as quickly as we can into audience back and forth. So first, Reva Siegel is the Nicholas Katzenbach Professor of Law at Yale University, where her scholarship focuses on, among other topics, law and inequality. Jocelyn Samuels is a senior counselor to the Assistant Attorney General for Civil Rights at the U.S. Department of Justice, overseeing the employment, litigation, and educational opportunities sections of the Civil Rights Division. Adam Klein is a partner at Outten and Golden LLP and is the chair of the firm's Class Action Practice Group. Kenneth Marcus is executive vice president and director of the Anti-Semitism Initiative at the Institute for Jewish and Community Research and author of Jewish Identity and Civil Rights in America. And last but not least, Olati Johnson is associate professor of law at Columbia Law School, where she teaches legislation and civil procedure. So please, let's take a moment and join me in thanking this terrific panel. So I'm going to begin and ask each of you to respond briefly, 3 to 5 minutes, to the most general of questions. In 2011, why does disparate impact matter? Does it? And if so, what are the reasons? What does it mean in the 21st century? Reva.
So I want to start by just making an observation about something I sometimes call racial common sense. When one sees a workplace in which there's pronounced racial stratification or gender stratification, does one look at the alignment of race or gender and an employment hierarchy and see it as the natural outworking of taste and talent? Or does one look at it and see the possibility of some kind of discrimination, whether past or present, might have played a role in shaping distribution of people in the organization? And there are some who see stratification itself as simply a reasonable allocation of a meritocratic order, because at the root, there's an assumption of fundamental racial or sexual difference. There are others who see that same picture and see something is wrong, either was wrong or is still wrong. So that's my first point. So if one looks at dramatically stratified workplaces and is the kind of person, has the kind of common sense that's worried that, sees similarity more than difference amongst people and worries about the possibility of discrimination, then, on my view, the disparate impact framework is a very powerful tool for doing a very important thing, which is asking institutions to take a second look and make sure that the practices, the facially neutral standards, whatever, that they're using that might actually help perpetuate or exacerbate historic forms of inequality are in place for a good reason, that they're good reasons, non-biased reasons why they're there. If they're there for those good institutional reasons, the standard will ratify them. But it requires us to at least take a second look. That's its virtue. Now, why take a second look? And for my 3-minute version or 4-minute version of this, I'll just give 3 possible reasons that someone of my kind of common sense would have concern. So there's different kinds of bias that are possible in this situation. One of them is the old friend, hidden, covert intentional bias. People who engage in it in our society often have the sense to keep their mouths shut. So there's that possibility. That's point number 1. Second point, there's the possibility of unconscious bias, the case in which a decision maker applying legitimate standards is applying them in systematically biased ways that he or she does not in fact recognize. The problem of implicit bias or unconscious bias, where the agent is unaware of his or own, has good intentions but is not aware. And there's plenty of social science evidence, which I won't discuss now, that demonstrates, as a matter of fact, that this kind of bias is prevalent. Okay? The third, we could call structural discrimination. In institutions even where there are decision makers who are not engaged in hidden intentional discrimination and who are not engaged as individuals in biased application of neutral standards, there is still a possibility of institutional inertia that will carry forward the past distributions. And this standard is going to ask the institution to take a second look. That, I think, was probably my few minutes, so I'll stop right there.
Thanks very much. Go ahead, Jocelyn.
Well, thanks very much. I'm delighted to be here. I'd like to talk about disparate impact as used by the Civil Rights Division in this administration. We consider it a critical tool to our work of promoting equal opportunity in the workforce. One of the things that it does, and a very important thing that it does, is to promote fairness and a focus on qualifications. As Alan said, this was one of the original purposes of disparate impact theory, to make sure that Title VII's promise that race, national origin, sex, religion would be irrelevant to decision making and that qualifications would come to the fore. I've lost that sentence, but in any event, that is a critical purpose of disparate impact. And in fact, Chief Justice Berger, writing in Griggs, said, Congress has not commanded that the less qualified be preferred over the better qualified simply because of minority origins. Far from discouraging job qualifications as such, Congress has made such qualifications the controlling factor so that race, religion, nationality, and sex become irrelevant. So that's the goal. And it's one of the situations in which actually I think equity and efficiency coincide that when an employer is using a practice, whether unintentionally or not, that unnecessarily excludes qualified applicants, that the employer is selling itself short. It is not identifying people who are truly qualified to do the job and is creating an artificial barrier to consideration of qualified applicants. The reason that that is particularly important in the context of our enforcement of Title VII is that public sector employers, and that is the jurisdiction of the Department of Justice, we enforce Title VII against state and local government employers, use tests, whether they are written cognitive tests or physical fitness tests or personality tests, as a routine means of assessing qualifications. And we may all think, and I think that there is some perspective out there, that tests are some objective measure of qualifications. But what we've found in our work in this area is that tests often fall short of identifying those who are truly capable of doing the jobs, whether it's because they don't test for the panoply of skills and abilities that are necessary to do the job. So written tests, for example, test for one component of what may be necessary to be a police officer, but they say nothing about judgment, about ability to perform under stress, about physical fitness. And so where an employer either requires too great a level of a particular characteristic or weights it too heavily, that can create a disparate impact that erects an unnecessary barrier. It may be that a test simply does not measure the skills that it purports to measure. The employer may well have identified the skills that it wants to test for, but have an imperfect instrument. The employer may set cutoff scores in a way that bears no relationship to ability to perform. So, for example, if there is no evidence that someone scoring an 85 will in fact do better on the job than someone scoring a 75, once again, common sense and the law say that that cutoff score should not be used. So in the employment context, disparate impact remains a critical tool to be able to ferret out and encourage employers to address these kinds of unnecessary barriers. I'd just like to say very briefly, we also use disparate impact as a very important systemic tool in our enforcement of housing discrimination laws, as Alan mentioned. And we've entered into a number of settlements recently that rely on a disparate impact theory. It is really critical in that context because what we have seen is that there are thousands of borrowers who are often excluded from eligibility for loans or charged higher rates on loans, who would be incapable of proving any kind of intentional discrimination against them, because what it really takes is a regression analysis that looks at statistics in the aggregate and identifies where it is that disparities between, for example, African American borrowers and white borrowers cannot be explained by any factor other than race. As a practical matter, disparate impact and aggregate statistical analysis is really a critical means of identifying barriers that individual cases would not elucidate. Finally, in the context of Title VI enforcement, particularly in the environmental justice realm, disparate impact is really necessary to be able to evaluate those kinds of things that have a particularly disproportionate impact on minority communities. And so we use the tool in all of these contexts and are fully committed to fully enforcing the law in that way.
I'll echo some of the comments that have been made by the prior two speakers. As a private employment lawyer, disparate impact analysis provides a tool that is very valuable to us. Given, as an example, we have a case against the United States Department of Commerce, the Census Bureau, and the facts are as follows. A client walks in, has an arrest record from 20 years ago for something where there's no disposition, was never convicted, was asked to submit the official court record of the disposition of the arrest. It doesn't exist. Query, does that violate Title VII? Well, how would the applicant know? How would any person in that position know that potentially they are the victim of discrimination? Moreover, how would they ever be able to state facts which would support a finding of intentional discrimination against someone or an entity that the only contact they've had is sitting for a 20-minute test and filling out an application? That's their entire interaction with the putative employer. So literally, there are no facts that the plaintiff could elucidate, could identify, which would satisfy the Iqbal plausibility standard to set forth the prima facie violation of Title VII for intentional discrimination. Having said that, the same facts that I just cited to you could support a finding of liability on summary judgment against the putative employer based on disparate impact analysis. So it's a very powerful tool. It also allows targeting hiring discrimination in a way that under Title VII that is really not achievable using disparate treatment analysis. And if you look at the statistics, I would suggest to you that my experience, and I think this is consistently the case within the government as well, that hiring discrimination is still the most sort of under appreciated or most challenging issue in employment law today. When you look at the unemployment rates for African Americans, twice that of whites. There are lots of explanations for it, and it's, as I said, it's very hard to target those kinds of practices using intentional discrimination theories. So the other nice thing, there's just other small points. One of the values of the Civil Rights Act of '91 and the Uniform Guidelines for Employee Selection Procedure requirements in particular is that it creates a professional standard. It creates a requirement to produce disparate impact analysis, to use validated procedures for making determinations for hiring decisions and other selection decisions. And it's a much lower standard of proof for the plaintiffs. A prima facie violation of Title VII under disparate impact is that there's a shortfall that can be identified through the systems that are being challenged. The defendant, the employer, then has the affirmative duty to defend the practices. They have the burden of proof and production at that stage. Makes it much easier to certify in the wake of the likely decision from the Supreme Court in Dukes v. Walmart. Disparate impact challenges to employee selection procedures and hiring procedures generally, I think, will remain viable, will probably not be directly affected by the Dukes decision. And so that's a very valuable asset as well. And so for those reasons, it really is a critical tool, and I think an underutilized tool by the private bar. We'll see what happens after Dukes, but my guess is that some of the private lawyers around the country that do Title VII class action work will look more towards disparate impact analysis instead of looking at social framework analysis and systemic pattern practice Teamsters type cases.
Well, I'm delighted to be here, so thank you for the invitation. This has been a great experience seeing some of the panels, and I'm here with some people that I've respected for quite some time. I have a slightly different perspective, I think, for a few reasons. The fact that I'm perhaps a minority on the panel as a conservative might be one of them, although I haven't asked everyone their views. The fact that my background is more administrative enforcement as opposed to courts may be another. For the most part, over the last decade or so that I've been thinking about these issues, I have agreed with the position that yes, a disparate impact matters, but have had that view for a couple of reasons, one of which I think is shared and one of which may not be. I have always considered disparate impact to be a very useful means of smoking out intentional and unconscious discrimination that can be proven in other ways, and that is part of what others, starting with Professor Siegel, started with. So I think it's very important that way. But overseeing civil rights enforcement agencies during the George W. Bush administration, I also had the concern, based on a perception, whether fair or unfair, that the doctrine had been abused during some prior administrations as a means not of, and when I say abused, I don't mean in any sort of corrupt or pernicious sense, but I mean in a way that's not consistent with my sense of what should be done with it, as a means not of smoking out discrimination, but of leveling other sorts of inequalities. That it is often the case that an administrative enforcement agency finds different sorts of inequalities which may be correlated with race but not because of them, and that in taking legal action might be, how shall I put it, diverting resources away from the cases of bias and bigotry that I think should be the focus of civil rights enforcement, and towards other cases which are about other sorts of things. So my view had been that this is very important. Certainly disparate impact is something that we talked about a lot, as it's talked about a lot nowadays in the new administration, but it was from a sense of skepticism as well as enthusiasm. Enthusiasm that it is a necessary means of finding real bias and bigotry that can be found in other ways, but skepticism that it can be abused. Now, there are a couple things that happened that made me wonder, not about those views, but about how much it matters, that makes me sort of think about it. I testified on disparate impact about a year ago, and one of the other panelists testifying before a congressional committee was a leading civil rights advocate who had appeared before me when I was in government, and who greeted me with a warmness that I found pleasing but surprising. And she reminded me what I had forgotten, which is that she had brought disparate impact cases before me, and I had approved them all. I had found that there was discrimination. I thought, well, that's nice. At least I'm getting a warmer reception than I otherwise might have today. And then she paused and said, we gave you only solid cases. And I said, well, that's what I was looking for, and that was actually what my concern had been about the other cases that I didn't want to see. Then I had a conversation with a career colleague from a different agency that I had headed at a different point of the George W. Bush administration. This was while I was still in the government. And I was concerned because I had not seen very many disparate impact cases at this agency. I'd seen more of them at HUD, but not at Office for Civil Rights and Education. And I was a little concerned because I had let it known that I want to see the disparate impact cases. And I was worried because in government, you may be aware, in government, if you measure something, you get more of it. If you scrutinize something, you might get less of it. And what I was afraid of is that career people, knowing that I was scrutinizing disparate impact cases, might be shredding them or saying, we don't want to deal with them. And I wanted to make it clear that, no, I don't want you to get rid of them. I just want to make sure that if we're going to go forward, that we have solid cases. And it had been my sense that in the prior administration, there had been lots of disparate impact cases going through the agency, and I was a little bit concerned why the numbers were going down. So I said, well, are there cases that you would have brought to Norma Cantu in the last administration that you're not bringing to me? Why are there so few of them? And she paused for a second. She said, no, we give you all the same cases. We just don't call them disparate impact. We call them different treatment, and you say they're fine. I still don't entirely understand that. I still don't understand that because it seems to me that there should be a large number of cases that you could only characterize as disparate impact if they're going to go anywhere. And yet it turned out that it hadn't made such a difference, at least in that case. I imagine that sort of conversation probably never went on at the Department of Justice, where I think that the communications have been different during the administration, but that's how it was. So that made me wonder, well, how much does it matter? And we'd have to have sort of a long conversation about the elasticity of the of the different treatment doctrine, which is sometimes used in ways that are not entirely intuitive. I do think that it is important that disparate impact be used properly. I think it should be used aggressively. I have been suspicious when I wasn't getting the cases, but at the same time, I think that it needs to be looked at with a skeptical turn of mind in those instances where enforcement resources are a zero-sum game and where focusing on some cases means not on others, and where it has always been my preference to focus on those that have the greatest likelihood of finding actual discrimination, because I believe there's a lot of it going on out there, and it needs to be addressed.
So, good morning, everyone. at some point in this panel, I know we'll start getting a little depressed about something, because it always happens in these panels that we decry the Supreme Court. We have some sense of pessimism. So I just wanted to begin on a note of optimism, at least. And that's just to say that disparate impact is not a dead doctrine. It still lives in the Title VII context. When people talk about Title VII, they're talking about fair employment. I looked at cases after the Supreme Court's decision in Ricci and see that there are still cases being decided favorably to plaintiffs. There are Title VII cases, Lewis versus City of Chicago. There's ongoing litigation in New York. And it's not a dead doctrine. It's certainly in the Title VI context. Most people don't know what Title VI is. I'll talk about it a little bit later, but essentially it applies to discrimination for all entities that receive federal funds. So it's incredibly broad. So it has a regulatory disparate impact standard. The court said you can't enforce it, but there's still work that agencies are doing under it. So even it lives. And it also lives in practices, and Alan alluded to this, and the fact that there are all sorts of employment practices, institutional practices that have changed because of disparate impact in ways that we have to celebrate and realize. So I wasn't set up to respond to exactly what Kenneth said. So I won't in its entirety, except for to say that I think you are getting to a challenging question, which is what we mean by civil rights enforcement, what we mean by equality, and whether anti-discrimination and rooting out bias is really our only goal. Now, it may be that our goal is just this sort of narrowest form of imagined bias that seems like bigotry out there in this world. It's not clear to me that that has ever been solely the goal of civil rights enforcement. If you look at Griggs itself, it talks not just about rooting out covert bias that it assumed existed. It said, here's the Griggs case. You had a situation in which they instituted a high school diploma requirement for a job that apparently didn't need one. Okay, so this is a kind of short version of the facts. So it could be that they did that because they wanted to exclude black workers, and it's a hidden bias situation. It could be because they thought they needed that high school diploma and weren't thinking about the fact that it might have an impact on a particular group. And so the question for me it raises is what are our goals? And I think they're broader than just anti-discrimination. They're really about inclusion in the fullest and most robust sense. I think disparate impact, both in the doctrinal narrow sense, how it's used in courts, and more broadly as a concept gives us an entry to that. I thought Reva really set out a broad and a great explanation of all the ways in which we use it and why it might still be relevant today. One thing I would add, and I think, I'm not sure it's entirely different, but I think it fits in within this rubric, is a notion that I get from Glenn Loury, who's an economist that some of you may know, and a social scientist who writes and talks about stigma, and he's really right now very concerned about issues of mass incarceration, and he talks about it in terms of a kind of politics of indifference. Would you have made the same action? Would you have done the same thing if this affected white people in this way or men in this way? And I think particularly when we're looking at legislative actions, I think we can ask that set of questions. So to be more specific, let me just say one thing, and then I know we're going to get into this more. When I want to talk to people about disparate impact outside the fair employment context, it's been so important in fair employment, but it's also been important in other contexts. I use the example of an LA Transit case that I worked on when I was a law student. I was an intern at the NAACP Legal Defense Fund, and I was really thinking, do I want to be a civil rights lawyer, or do I want to do issues based on poverty and class that really deal with contemporary notions of discrimination, which are not just discrimination. They're about spatial inequality. They're about who has access to resources. And the Legal Defense Fund's LA office brought this case involving disparities between funding for rail, which serve predominantly white commuters, and buses, which serve predominantly inner city minority commuters. And they brought it under Title VI, using both the intentional discrimination provisions and the disparate impact provisions at the time when there was a private right of action to enforce the regulations. And I think the case shows all of these questions about, well, in some sense, this was just a differential treatment case, right? And it might have been just a good intentional discrimination case, but it was also asking a broader set of questions. Who's at the table when we decide how we're going to dispense transit resources? How are we going to think about not just connecting suburban commuters to their jobs, but think about connecting people who live in the inner city areas to their jobs in the regional economy? those were the questions it was trying to force us to ask. So that goes beyond an anti-discrimination lens. Anti-discrimination is the root, it's the entry, it's what disparate impact gives you. You ask, why are you making this decision? Do you have justifications? Do you have alternatives? But it's in service of this broader ideal of inclusion and connecting people to our economy and to full participation in our lives.
Thanks very much. Reva, I wanted to pick up actually a little of what Olati had said. Most of the panelists talked about disparate impact as an important tool for reaching types of discriminatory intent that are hard to smoke out, to use Ken's term. But Olati, it seems to me, is making an additional point, which is setting aside all those different iterations of types of bias. Are there some categories of things that disparate impact analysis both can do and should do, can constitutionally do, that really have nothing to do, not so much to do with bias and more to do with other values and perhaps more, other equal protection values? And you, Reva, mentioned covert bias, implicit bias, and institutional bias. And I wonder if the institutional bias falls into that category, or if you could talk a little bit more about what that means as a practical matter.
Olati just raised the issue of Griggs itself, and I actually thought I'd just go back to the case just one more moment as an interesting context for thinking about what we might mean by this notion of institutional bias. I think it's implicit actually in the remarks of a number of people who've spoken right now. So the first categories, well, let me just, so the Griggs facts. Interesting fact about the Griggs case is that the employer at issue there, the defendant employer, had been expressly discriminating on the basis of race until the effective date of the '64 Act. And only when it became unlawful did the use of the test and the diploma that's at issue in Griggs get put in place. And some of the existing, and there's a segregated workplace with different wage rates, and some of the employees who were already there were grandfathered in even though they didn't have the relevant criteria. So the court could have talked in intentional discrimination terms, could have focused on bad purpose. But the weight of the opinion, it goes to the fact that in North Carolina, there had been inferior segregated schools, the court points to. Now, the school system was not in that case, but the court looks to it as a background fact to understand something about why the requirements imposed there were going to carry forward past inequalities. And here, so you could say, well, the employer could have had bad purpose, but whether or not the employer had bad purpose, the employer shouldn't be imposing requirements that perpetuate past wrongs, past bias, or perpetuate past inequalities in whether we want to say human capital, in ability to participate, in human network. We could talk about whatever the background inequalities are, unless the requirements are related to the institution's purposes. There's a business necessity, a good business reason. That's the idea of probing the functional significance of the requirement. Or a different way of asking it is, given the exclusion that this is going to perpetuate, is it worth its cost? Now, Title VII, as a context for applying disparate impact, is allowing the employer to be free to make those decisions so long as they're on the basis of qualifications and not because of race, not because of sex, right? We could, so in that context, the idea of institutional discrimination is not that somebody had a bad purpose or even an unconscious bias, but that the criteria the institution's using either legitimately or illegitimately are carrying forward other social inequalities. I think that's a basic understanding of it. In other settings, for example, in the administrative setting or in other contexts where statutes incorporate impact standards, there are other decision makers, other processes, we could imagine an impact framework doing other kinds of work, other kinds of goods. And I think it does. I think that the mass transit example that we've just been hearing about is a beautiful one right there. So, you know, I would sort of make a contextual answer. Statutory context or legal enforcement mechanism is relevant.
Jocelyn, related to this, I recognize that sometimes when you're a government lawyer, the answer to a lot of questions is, I can't say. But insofar as you can say, maybe you could talk a little bit about the decision-making process on how to use disparate impact in the current Civil Rights Division. And if there are some cases, past cases, that you can refer to as examples, that would be great.
I appreciate your sensitivity to my institutional constraints. I guess picking up from what Reva said, I would take issue with Ken's assessment that using disparate impact to do anything other than smoke out intentional bias is somehow an abuse of the theory or an extension of Title VII beyond its intended reach. As Reva points out, Griggs itself looks at the impact of a high school diploma requirement that obviously reflected inequities in the school system, even assuming that the employer had no hidden bias or intent to continue inequitable practices. So I think the touchstone that we look at is unnecessary barriers. We don't bring cases based on the numbers alone. We don't look at a result and say, oh, particular groups are being excluded, let's rush in and correct the practice, because again, as Reva noted, Title VII doesn't bar employers from using selection criteria, even if they have an exclusionary impact, if in fact there's a close enough fit between the qualifications and the criteria being used. So what we look at is, are there particular criteria or practices that are unnecessarily excluding individuals, whether they are African Americans, Hispanics, or women, from employment opportunities. And I can talk just a little bit about our lawsuit against the Fire Department of New York, which has been going on since 2007, and challenges written examinations given to entry-level firefighter candidates. And one of the things that is a red flag of potential problems is the representation of African American and Hispanics in the New York City Fire Department. Again, we're not looking at this as the sum total of the inquiry and the thing that triggers a lawsuit, but it certainly suggests that the employer has an obligation to go further in evaluating the reasons for these levels of underrepresentation. So in New York City, African Americans and Hispanics make up about 25% of the city's population, each group. In 2007, when we filed this lawsuit, African Americans were 3.5% of the firefighters, and Hispanics were 6.5%. Now you could say, well, that's just because of choices that particular people in the city made, and it's the product of other constraints that have nothing to do with employment and shouldn't be addressed through the disparate impact theory. And that was something that we looked at in investigating whether or not to bring this lawsuit. But as a comparison, if you look at other cities' fire departments, you see a much greater representation of African Americans and Hispanics. So for example, in Los Angeles, 14% of the firefighters were African American, and 30% were Hispanic. And even in New York City itself, if you looked at other public safety departments, like the police department, was 16.5% African American and 18% Hispanic. These kinds of numbers are a tip-off that there may be a problem that needs to be addressed. The problems were so significant that the court in that case, this was Judge Garifas in the Eastern District of New York, granted summary judgment to us on our disparate impact claim. This is a very rare occurrence, I think, summary judgment saying that the practices had disparate impact and were clearly not job-related and consistent with business necessity. He then went on 6 months later to grant the plaintiff intervener's motion for summary judgment on a disparate treatment theory. But here's what he found about what the city had done in that case. He said, the city has failed to take measures to ensure the reliability of the examinations. It has failed to take steps to ensure that the reading level of the examinations was appropriate. It has failed to test for various recognized important abilities of a firefighter. It has failed to test for abilities needed upon entry into the academy, rather than abilities to be learned on the job. It has failed to retain testing professionals to devise the examination questions, and it has failed to demonstrate that the examinations it administered actually tested the abilities it intended to test. Compounding these failings, the city has imposed arbitrary pass-fail scores unrelated to the qualifications for the job of entry-level firefighters, and has constructed eligibility lists based on distinctions in test scores that are unrelated to corresponding differences in the qualifications of firefighter candidates. Given the manifest lack of fit between qualifications necessary to do the job and the selection criteria that the city was using, this really stark exclusionary effect was completely unjustified. And I think Title VII is an absolutely appropriate and valuable tool to address situations like that.
Thanks very much. Adam, similar question, but I guess a little more forward-looking. Are there particular kind of innovative approaches that you're seeing in practice or maybe using yourself for utilizing a disparate impact cause of action?
Well, as I said before, I think it could be a very valuable tool going forward in the face of what the Supreme Court will do in the Dukes v. Walmart case. I mean, it is, even before the Dukes case, this is a little wonkish, but I'll explain it. The circuit courts have raised the bar on what is required to certify class actions across the board, and it's had a significant impact on Title VII. So their so-called IPO, or hydrogen peroxide decisions, have explained that there's a requirement to evaluate the merits of the case if those facts also support requirements of Rule 23. And the problem with that is that it's ratcheted up the cost and complexity of prosecuting a disparate impact case, a intentional discrimination class action case. The quantum of evidence on causation, on trying to link policies and practices that are challenged with the observed outcomes in terms of shortfalls for pay and promotion decisions or hiring decisions. That's the effect. The causal link, the evidence in support of that is hard to adduce through discovery, and it's costly and time consuming, and it really has become very challenging to invest the kinds of resources to establish enough evidence to satisfy that standard. And the Duke's decision presumably will increase or ratchet that up again. In contrast, disparate impact is really sort of the flip side of the same coin. Whereas in Teamsters, intentional discrimination, pattern practice cases, you need a very substantial volume, quantum of evidence. On disparate impact, the prima facie violation is that there's a shortfall based on selection criteria that hasn't been properly validated. And the defendant has the burden of proof and production once a prima facie violation's been determined. And the other thing is that it's sort of observable, independent of whatever the client knows about. So as an example, to use the New York City firefighters, New York City is sort of a special case. I'll tell you as well that there are roughly 28 female firefighters out of 11,000. So this is a department that's had serious issues in terms of its employment practices, and that can be objectively observed. And so the nice thing is that, unlike an intentional discrimination case, an applicant denied employment at the New York City firefighter who's a woman, we pretty much know what's going on. That on a statistical case basis, it's hard to fathom how an employer could support that that number of women working within the firefighting department, or where there's a test itself that's identifiable that we can evaluate through an expert. In other words, in the disparate impact parlance, you can look at the challenged selection criteria that is the subject of the lawsuit and really make an assessment, independent of discovery, before the litigation about whether it's a proper selection tool. So as an example, in a case against the Department of Corrections in the state of Connecticut, we challenged female applicants for a correction officer position, you ready for this? Based on the adverse impact created by a 1.5-mile timed run test for corrections officers that had impact for women. Now, it's not particularly surprising to find that the use of a 1.5-mile timed run test, when it has impact, would not be significantly correlated to the performance of the job of a corrections officer. So it is, I think, those kinds of opportunities that are out there where you can identify violations of Title VII, don't require the significant investment in trying to adduce facts which would support intentional discrimination to satisfy the Rule 23 requirements and the likely additional requirements that Dukes will lay out.
Ken, if I can riff off that last example a bit and get to this point of whether there's a legitimate space between, disparate impact to smoke out bias and other purposes. Let's take this corrections example. If a corrections department has a run test, it's not only has it not been proven to be correlated with job performance, but is demonstrably not probative. But no one's claiming that it was adopted with discriminatory intent, and there's no evidence that it has been. Yet we know that it disproportionately excludes women, and that women have been disproportionately excluded from this job category historically since the dawn of time. In past examples for explicitly discriminatory reasons, is that, in your view, is that a legitimate space? Is that a legitimate purpose for using disparate impact, or would one really, in your view, have to have some additional indicia of intent, even if that's implicit intent?
I would want to see something else, although it would not have to be that. Let me say that the thing that I believe disparate impact should smoke out is not just intentional discrimination, but also unconscious discrimination. And I would even add the third element that I think Reva mentioned, but I might not have heard it quite right, which is institutional arrangements which are not based on current intentional or unconscious discrimination, but are based on prior intentional discrimination. So if it's a prior intent, then what I am more suspicious of are what Jocelyn referred to in what I think is a fairly conventional analysis, where she referred to disparities that are the result of practices that unnecessarily exclude blacks or women. Right? That's where I think that there's a concern, is practices that unnecessarily exclude, and Adam gave one example there. So there needn't be intentional discrimination, there may not be unconscious bias, and it's not the case that we have a practice based on the fact that 40 years ago they wanted to exclude women or black. It's just they have these sorts of arrangements. What I think is necessary in order to square disparate impact with equal protection and to make sense of it as a matter of enforcement resources is something like a good faith exception. And that's something that others have also argued, which is to say, if there is no exception for good faith, no way out, if you can say, as this business matter, it wasn't necessary, but I've got a good reason why I'm doing it. I think you should have that as an out. Now, here's why I think that that's necessary, and it's not necessarily from Adam's case, but I think it appears elsewhere. If you don't have that exception, and you say that if there's a disparate impact, that an employer or a school or a bank is on the hook whenever there's a disparity that they could have removed, without a business necessity, the fact is nowadays you can eliminate all sorts of disparities if you focus on it hard enough. Certainly in testing cases, it's getting to the point where if you change the ratio of a written to a non-written test, if you make other sorts of arrangements, using standardized tests that are used frequently enough, you can get to different sorts of balances, right? So if the question is that we want to get to eliminate a disparity, a rigorous use of disparate impact focused on this business necessity rule, but without a good faith exception, seems to me to push us to the point where you almost have to design every test and every practice in a way that will exactly reflect the numbers that you're aiming for. In other words, that will get you to a quota, which I think is not what anyone is really looking for, and is not consistent with equal protection. And so for that reason, I would insist on a good faith exception. Now, in the example that Adam raised, whether anybody could show that they have a good faith reason for perpetuating this system, I don't know. I would look with a skeptical eye to it and try to find out, well, why are you doing that really? So if there is a reason, I would say, okay, even if it doesn't meet the requirements of business necessity.
I'd love to probe that a little more, because if business necessity isn't the good faith exception, and I assume from the sophistication of your argument that simply proving that you had no hatred for the excluded group in your heart is also not sufficient to evade liability, what as a practical matter would be evidence of a good faith exception under the kind of theory that you're promoting?
Well, necessity, I mean, there are lots of different standards. Necessity is higher than some other standards that you might have. So I would look for a legitimate reason that may not rise to the level of business necessity. I'm not saying that legitimate reason is the exact formulation that I would use, but I would want to know why are they doing it, and even if it doesn't meet the notion of business necessity, if there is a legitimate good faith reason, even if not a necessity, I think that that's not only appropriate, but perhaps a necessary emendation to the statute in order to meet equal protection requirements.
Okay, thanks. I'm going to turn to Olati, but I also want to give the audience a heads up that I'm going to next turn to you. So you should get your questions ready, and as I said, I'm going to ask you to raise your hand, but then also wait for the microphone so that we'll have a chance to get your question on record as well as the answer. Olati, you should obviously feel free to respond to anything you've heard, but I guess my proactive question to you would be about the institutional issues that you discussed relating to Title VI, and particularly because the Sandoval decision took the private cause of action away in the Title VI context. Folks have had to be innovative. It also there's been a lot of reliance on administrative enforcement and voluntary compliance and the like. And I wonder if you could talk a little bit about what that means in practice or what it should.
Yeah. So my pitch is always don't just think about the litigation context, also think about the administrative context. That said, as a former litigator, I can't help but respond to something that Kenneth said. The litigator in you never dies as much as you try to be compliant and into voluntary resolution of matters. I do think that the business necessity test, actually, when I first learned it as a litigator, I thought it meant like you have a gun to your head and you have to adopt this practice, but of course it doesn't really mean that, and you don't want it so watered down it means any reason, and I'm sure Adam and Jocelyn can talk more about that, but it's not a terrifically, it's not an impossible standard to me. It's not even a terrifically hard standard, and some courts have substantially watered it down in ways that I don't think are very good, but should fit your sort of as a descriptive matter. It's not a very tough standard, and it's also not. It's not usually easy for people to cite a number of cases where they really think disparate impact has been misused. I mean, in the fantasy world it is, but just this sort of idea of, oh, it's just used ruthlessly to kind of just police all sorts of disparities, I'm not sure that responds to reality. But then I'd also just ask the broader reason of why wouldn't you want a public employer who is supposed to be protecting us in terms of, I live in New York City. I actually am obsessed with the fire department. I go visit the Morningside Heights Fire Department every day. Not because I walk right by there, and I talk to the firefighters. And there's one woman and there's one African American, and I am so fascinated all the time by their stories. Bring them to talk to my class, and the simple story in New York is that those jobs are incredibly valuable, as they are in a lot of other cities. And they're the jobs that people with high school degrees can get. And so there's what sociologist Chris Tilley would call opportunity hoarding. It's simple. And some groups have hoarded those opportunities better than others. But the question is, why, as a public employer, wouldn't you want to have the best employment practices? Why wouldn't you want to include the most number of groups? It's not about quotas, really. It's really about inclusion. So outside the litigation context, I mean, I think I wouldn't quite call it a happy ending, but there's some good part that has emerged from the demise of Title VI's private right of action, which may just be temporary, may be fixed legislatively, it can be fixed. So Title VI, remember, it applies to all entities that receive federal funds. Every federal agency has a regulation that says, you can't discriminate on the basis of intent, but you also can't adopt practices with a disparate impact if you receive federal funds. So as you know, we live in a society where there are lots and lots of state and local governments that receive federal funds for a range of projects. And so Interestingly, the Department of Transportation has been one of the agencies that has adopted a very robust set of regulations, some of which were adopted after the Sandoval case, that implement and further explain what we mean by disparate impact. And so those are things like requiring entities that receive federal funds. This is all sort of conditioned spending. So they're saying this is a condition of receiving federal funds, that you should think about whether or not when you make a change in how your transit system is designed, or you increase the fares, you abolish routes, think about its impact on groups that have been historically disadvantaged, on people with limited English proficiency, on people with disabilities. And make sure you're including people in terms of the public hearings that you have when you evaluate information. And so it's requiring an affirmative assessment of its impact on various groups. And one question in the administrative context is always, okay, so you're required to do that as a condition of funding. Is that, what does it really mean? And I want to say that it is one of those things that means what we as members of civil society make it mean. You hope that most entities do this just because they're required to do this, okay? They have to continually reapply, they have to certify, and it's supposed to be monitored by the federal government. But it also really matters what outside groups do, what kind of monitoring they do at the state and local level, and what kind of complaints they bring to the fore. And so the last thing I'll say on this front is that a recent example that I'd say in the end is sort of a mixed success example, though, of someone enforcing these Department of Transportation provisions involved the transit system in San Francisco, which is known as BART. I don't know if anyone's ever taken it. It's funny for someone who's a New Yorker, who lives in New York, because it's so limited, but it's very important in terms of connecting people to all of these to jobs in the regional area and decreasing dependence on cars and all these other kinds of things. Okay, so they were going to extend the BART system, and the question was, are you going to extend it in ways that allow residents of the East Oakland community to benefit? BART was receiving $70 million in stimulus funds to do that, and some groups in San Francisco and the Bay Area said, no, you can't do this BART extension in a way that doesn't take account and assess the environmental impacts, the impacts on groups of color, on Latinos and African Americans. The federal government held up the funds, and they didn't give them their stimulus funds. And so something like that was a case in which the federal government responded. And of course, it's going to vary across administrations, but some of these requirements around limited English proficiency and environmental justice were supported in the Bush administration. The limited English proficiency requirements, making your agencies open to that. That's an enforcement of Title VI's disparate impact, but it was something that had the stamp of the Bush administration. So I think that there's a lot you can do even across administrations on this issue, and so I wouldn't neglect the administrative enforcement context.
So now that Olati's done dissing the BART and its puny coverage area.
And I have to say, I take BART whenever I go to San Francisco.
Yeah, don't try to clean it up now. It's too late. I did want to note that the Opportunity Agenda, it will be doing with ACS a white paper on a mechanism that we're recommending, an opportunity impact statement process for this kind of internal compliance with the variety of civil rights laws, but especially those that are connected to federal funding. And so hopefully that'll be out maybe at the end of the summer. Okay, so let's have hands, and we are going to start with this gentleman here, and if you can wait for the microphone. And the other admonition, as you know, is please ask a question, not a statement, and try to be relatively brief.
Alan, at the end of your introductory remarks, you made a reference to McCleskey versus Kemp, which, as I assume most of the people in the panel know, involved 230 regression variables. And I was just curious, in the context of civil litigation, how much of a negative impact has that decision had on work in this arena, if any?
Yeah, Adam, do you want to start? And anyone else who wants to chime in?
Yeah, well, I think the statistical modeling is a complicated issue in these cases, there's no doubt. But a lot of times what you're talking about are very simple jobs. First, as an example, the correction officer position, their minimum qualifications, they're pretty transparent. I think that a lot of times the disparate impact cases really sort of boil down to a couple core issues, and it's hard to know exactly in a case like that what the actual impact is. I don't know if others have a view.
I would just say that, of course, in my view, a horrible decision, McCleskey. The perverse silver lining is that it did elevate multiple regression analysis as one way of showing causation, which the court actually did, embrace. It assumed to be accurate, and which is valid for demonstrating disparate impact, even though it was found insufficient for purposes of the Equal Protection Clause. And so I actually think that it has raised the level of sophistication in the civil litigation context in some ways that now, for various technological reasons, are actually even easier to demonstrate. So I wouldn't take the trade-off, but I do think that there are some positive side effects that have come from McCleskey and the particular way in which the McCleskey decision was articulated. Let's take another question. Yeah, Josh.
Josh Sivan. I was struck that none of the panelists have mentioned the less discriminatory alternative prong of disparate impact analysis. My sense is that it essentially says that if an employer or another entity is faced with a better way of doing something which is less discriminatory and it doesn't use it, then it should be liable, because what's the reason for not using it? And I'm curious what the panelists think about how less discriminatory alternative plays into the rhetorical and legal justifications of disparate impact.
Anybody want to take that?
Well, I guess I'd turn that into a question for Ken about whether, as Josh says, a refusal to adopt a less discriminatory alternative offers some of the kind of proof of something veering more toward intentional discrimination. If you know that you are using a practice that has impact and there's another alternative available, would that address some of your concerns about the use of disparate impact theory?
Well, I think it depends on why you're not using the less discriminatory alternative, and whether you have good faith, perhaps mistaken, or arguable reasons why you think that it will not serve your business needs or mission. I do agree that one approach for the courts could be, if not to construe a good faith exception, to interpret the business necessity in the way that you would consider to be diluted or watered down, which would meet my objections, but presumably not yours. I think the question of what to make of an employer who declines to use a less discriminatory alternative because they have perhaps controversial reasons for not wanting to use it. Maybe they think that the oral test or the I'm trying to remember in Ricci there were sort of practical exams that were considered, that these do not measure what they want, that they think that the written exam, which has an impact, nevertheless provides a way of evaluating analytical abilities which are important for some of the sophisticated needs of considering the possibility of explosives on the docks or some such things. I think ultimately it does come down to what I think a couple of you have mentioned, but it's the question of why do we want civil rights enforcement in the first place? For me, it is because we want to eradicate bias. In some cases, that's the hatred in your heart that you mentioned. In some cases, it's subconsciously treating some people better than others. But it's all about making sure that we don't have people treated differently because of their race, their gender, so on and so forth, which is what I think we should be focused on. There are others who would say that there are other legitimate goals that may have nothing to do with that, but have rather to do with the desire to be more broadly inclusive. And that if there are ways of being more broadly inclusive that an employer is declining, they should use them if they're available, because inclusion is a good thing. To me, inclusion is a good thing, and an employer who wants to use them should be able to use them. But an employer who doesn't use them, if it's not because of hidden bias, I mean, that is inequitable perhaps, but considering the great coercive power of enforcement, it's not where I would go with the mechanisms of civil rights enforcement, and in some cases will raise for me questions of equal protection. That's where I would come down.
Let's take some more questions here on the aisle, yeah.
Are there any states that have private rights of action for disparate impact in the kind of not Title VI areas, not housing, not employment? And is anything kind of going on with that that's interesting? And if not, are there efforts to kind of go that way to make up for the fact that that no longer exists? Outside the cases you can convince the federal government to look into.
Outten, you want to take that? Yeah.
Do you want to answer some of that? I mean, do you know?
Sorry, go ahead.
I
Go
only,
ahead.
at last count, had one state that had actually adopted it. It was Illinois, right? That had waived its, or maybe it was Illinois and Connecticut.
And California.
And California did, okay, so I'm wrong on my count. So again, reason for optimism. Now, 3 states waived their sovereign immunity for suit and said you could sue them under disparate impact regulations for Title VI. And there is effort. There have been efforts to go beyond that. There's also a Title VI fix, various Title VI fixes that have been before Congress, and including one that might be part of Department of Transportation at the federal level. I mean, at the state and local level, I would also just urge not just a concentration on sort of creating a private right of action, but actually creating any kind of infrastructure or mechanism for states and localities to really comply or enforce Title VI. It's as important that they empower outside groups to do it as they think about, well, what can we do more effectively in our practices that create these kinds of this kind of fairness? Because I think a lot of states and localities they just receive the Title VI funds, and they don't really think about, the federal funds, they don't really think about Title VI compliance in any sort of robust way, and it's an opportunity for them, that institutional context, to ask a broader set of questions. But I do think that those examples of private rights of action and restoring the private right of action is an important plank in the enforcement mechanism.
And Olati, your count may be right. California actually has a state analog to Title VI. They have a state statute,
okay.
but I don't think that they're on the right. I don't think they're on the list of states that have waived their immunities. So, but that's yet a different approach, where California is the only state that I know of that has post Sandoval adopted Title VI-like state legislation that includes a disparate impact standard. Yeah, go ahead.
I actually I don't know our frames here. I wanted to just respond a little bit to the Josh-Ken exchange earlier, just to put one more observation on the table, because our time is short. And that is that the disparate impact framework, which asks about the business relatedness of practices and has this rebuttal, which asks about least restrictive alternatives, is putting a bit of pressure. It's nudging the employer to essentially make sure when you use practices that they are they have functions internal to your enterprise. They're qualifications that are important to get the job done. If they are, they're legitimated. If it's not so clear that they are, if there are other ways of going about it that are less exclusionary, the statute's putting a nudge on the employer, that's not good enough. And it's a standard that actually isn't, as Olati was saying before, it's not necessary, nor is it merely I could think of a relation. It's somewhere between the two. And that standard is something that has emerged over decades of this nation's reflecting about living with a history which we know about, a long history of overt and embedded exclusion, right? So the question becomes, can Congress make such a judgment? And the answer has been yes. And when questioned about it, probed by the court, Congress said again, yes. And So it seems to me, it depends where you are in the legal system, the political system. This goes to the point that's being raised here. You could say, that's a bad idea, or that's a good idea. That's a conversation we should be in. But somewhere in here, the Constitution got raised. And I wanted at least to say that when this decision was originally made, it was understood to be enforcing, the Section 5 enforcement power. It was understood that Congress was enforcing equal protection, and it's been reaffirmed in those terms. And when Griggs came down, there were, I think, a majority maybe of circuits that read that opinion as also making sense of equal protection requirements for public employers, meaning constitutionally required. That was the understanding then for many judges of the Equal Protection Clause itself, not constitutionally suspect, but constitutionally required. And over the decades, it's now been probed, and it's much more understood now that it's a permission rather than required, right? But that's decades of understanding. That's even Davis. And that's an important understanding to hold on to here. So to circle back to the conversation we were having with Ken, the issue, we should argue with one another, but as a federal judge, if you're not legislating from the bench, then you leave it to what Congress put there. And that's kind of being probed at the moment, and I wanted to get that into the conversation before this session was over.
We had a hand over here, yes.
So,
Wait for the mic, please.
So I note, Ken, you keep focusing on good faith rather than business necessity, and I take it that business necessity is not enough. That's why you do that. And I think the unstated premise that I'd like everybody to respond to, if I'm right, is the sense that at a certain level of refinement, job qualification is unmeasurable. You use the example of weighting tests at 60-40, and maybe there is truly no differences in a measurable, meaningful job qualifications way between a 60-40 weighting or a 70-30 weighting, and this is why you fear that the result will be quotas. And if that's right, then the alternative, less discriminatory method prong actually makes things worse. I think this has been the argument, one of the arguments against disparate impact for the last 4 years. I don't think that we have reached the point, that level of refinement. I don't know if in as a matter of practice we ever will. But I wanted to have people's reaction. Do you think that that is a valid concern? In theory, if not in practice. And do you think that there is anything in the doctrine that responds to that concern?
Who wants to start?
Well, I'll say that if you look at the Easterling v. Department of Corrections decision, the Judge Janet Hall goes through the history of the legislative debate that surrounded the Civil Rights Act of '91 in terms of fashioning the proper standard for business necessity. It was a discussion about what the proper standard would be. And the courts have interpreted it to either mean minimum qualification or significantly correlated to the performance of the job. I think that's a pretty low or reasonable standard from my perspective. And I think this is a solution in one of a problem. There are relatively few disparate impact challenges to employment selection procedures around the country. In fact, if you read that decision, it cites the Lanning, but very few other decisions. There are a handful, but there aren't that many. And this is not something or a situation where there are hundreds of cases filed challenging everything under the sun. Primarily, this is a challenge to public employers using tests or performance requirements for public service jobs. And I just, my sense of it is that it's a reasonable standard, one that Congress debated and the Republican president signed into law. And that's been used quite sensibly, and I don't see any evidence of abuse at all in my experiences.
Okay.
Oh, here's the problem that I see. As long as we have not a good faith exception and a business necessity rule, which is interpreted in different sorts of ways. The problem as I see it, and it's reflected in Ricci and in some other cases, is that if you are counseling a public employer that has some sort of disparity, and there are disparities everywhere throughout the economy, there are always going to be disparities at a minimum from random chance unless you have rigid quotas. So if you are counseling an employer that has disparities, you are very, very frequently on better grounds urging that things be nudged in a particular direction to get rid of them, even if there's no kind of bias involved, and even if in some cases it involves the sort of what I would characterize as being manipulation in Ricci. So the concern that I see is of that sort of manipulation and of moving towards treating people less as individuals, and I do see it as being something that comes out of the 91 Act. While we do have a history of racism and inequality and discrimination that needs to be taken seriously, we also have histories of politically motivated racial balancing that are also, I think, of concern.
Can I just
Yeah,
add,
go
I don't want to take up time here, but in Ricci, there was a union contract that set the 60-40. And so this is not a case of just the employer being pushed, having a reason and then being challenged on it. And if you look at the history of labor in that workplace, there's different groups representing different firefighters of color. So as to which narrative this story fits in, you know, you can read the Ginsburg opinion, you can read Justice Alito's opinion, you're gonna see different starting points for what went wrong. But in that case, it was not, how are we gonna do this job? This is the way to do it. It goes back another 20 years earlier. So.
You know, if I could just add, I think that it's always, the part of the problem with Ricci is that it's always possible to comply with the law in a way that violates some other law or some other principle. So if I stop at all the red lights, traffic lights, but I drive like a maniac so that I never have to get, stopped, but then I stop at the red lights, I've violated, another set of traffic laws. And I think the especially troubling thing about Justice Scalia's dissent is he conflates those. Even assuming that we think that the New Haven Fire Department violated either the Equal Protection Clause or Title VII's intent standard or both in allegedly trying to comply with the disparate impact standard, that says nothing about the constitutionality of the disparate impact standard as long as there is a constitutional way to comply with the disparate impact standard. And my fear in the way these cases are going to play out based on the Scalia concurrence is that that distinction is going to get conflated, and the assumption will be made that if anyone could conceivably, any municipality could conceivably try to comply with disparate impact in a way that violates disparate treatment or the Equal Protection Clause, then there's constitutionally suspect glance cast on the entire disparate impact standard. I think that's really a concern to be worried about. Let's get a couple more questions. Yes, here. Wait for the mic, please.
Other than appellate judges just making up the record, I could never understand in Ricci how the district court could grant summary judgment. The Court of Appeals could affirm the summary judgment, and then you could have the Supreme Court give summary judgment to the party with the burden of proof. When these cases actually get tried as they're supposed to a jury, I'd be interested in knowing what happens.
This is probably a question for a whole independent panel, but if anyone wants to react to that.
Well, I also say I'm not sure what the legal claim was, because what New Haven decided was not to certify the exam, and no one was promoted. So I'm not sure what the claim was in that case. But that's another. And also, just to complete the thought, a lot of the evidence or facts supported by the Supreme Court's majority decision were not in the record. This was the political discourse at the time. So it's a political decision. I mean, it's really just that simple. To answer the other, do they ever go to trial? I think these are largely summary judgment cases.
I think it's worth noting that the Supreme Court has been engaged in this practice of giving summary judgment in similar situations. I think it has something to do with the evisceration or the sort of inclination to grant summary judgment, and it's where the substantive issues sort of merge with some of the kind of procedural decisions that the court has been making in this area. The other thing that I always found really interesting about Ricci is that the court borrows the standard that it uses, and this is just in the weeds. I mean, for people who haven't read the decision, read it. But it borrows it from the constitutional context and brings it to the legislative context. And it's fascinating in light of what has been said on this panel, and the idea that are we gonna allow Congress to have a more robust place for realizing the ambitions of equal protection, even if it's a permission, right? Or are we gonna constrain them by our view, meaning the court's view of affirmative action cases? So they didn't allow Congress very much space by really borrowing from these affirmative action cases and using it in the disparate impact context. And I'm referring to the strong basis in evidence test that some of you can look at if you haven't read the decision.
Okay, I think we have time for definitely one, maybe two questions, depending on how succinct you are in answering. Yes, here in the aisle.
So I appreciate that disparate impact has an ongoing life in the employment context in public sector workforces, primarily police and firefighting. But the flip side of that is that the EEOC and the private bar bring remarkably few, almost no, disparate impact cases outside that context. So I just wanted to ask, why is this? And can and should anything be done to bring disparate impact in employment back into the arena where it started?
Jocelyn, is that an I can't say question?
Well, no,
or,
I mean, in part I can't say because I don't work for the EEOC. So I don't know about what disparate impact cases they have either brought as a matter of trial court litigation or weighed in on in their appellate capacity. You know, I can say that this administration as a whole has a commitment to robust enforcement of all of the provisions of Title VII, including disparate impact. And I know that the chair and the commissioners of the EEOC share that commitment. So to the extent that there are disparate impact claims in the private sector, I would urge you to encourage the victims of those practices to file charges with the EEOC and to work with them to ensure that those are fully investigated, because I know that they are receptive to doing so.
And just factually, I mean, I'm a private lawyer, we represent employees. We do bring disparate impact challenges involving hiring, pay, and promotion decisions. And the reason you see a lot of public employer challenges is that typically public employers will use civil service tests or selection criteria that are transparent and focus on tests or personality inventories or things that can be identified and challenged quite concretely. And you have an enforcement vehicle through the Department of Justice.
I think this gentleman here had his hand up. You're the last question.
I feel like we've danced around this a little bit, but I was interested in Jocelyn's opinion on this, but then we can sort of extend to the whole panel. So I assume that, I don't know the specifics of this fire department case, but I assume that they had reasons that they put forth some reasons for the standards that they chose. And I'm sort of wondering, here's a highly technical, life-saving, organization that deals with a lot of competing political and employment, factors. And are you comfortable judging how they choose their firefighters, and are you comfortable having a judge do that?
Well, I mean, this is something that arises all the time in technical cases. And, I think one of the things that, and this is in response to an earlier question about how disparate impact plays out in trials, Congress very consciously set the burdens of proof. And those are part of what it takes to make out a viable disparate impact claim. So one of the things that the Civil Rights Act of 1991 made clear was that post-Wards Cove, where the burden was shifted from the employer to the individual plaintiffs, Congress made clear that it is the employer's obligation to come forward with proof that a practice is job-related and consistent with business necessity. Part of that, of course, is because the employer is the one in possession of the facts that are necessary to evaluate the relationship between the selection criterion and the qualifications for the job. Part of that is, as Reva said before, because I think what the disparate impact provisions do is to urge employers themselves to take a very careful look at the criteria that they are using, and assuming that they are the ones who are in the best position to make an assessment, at least initially, about the fit between the test and the qualifications, that in fact they are satisfied that it measures what it is supposed to measure. Often, these cases are based on extensive amounts of expert testimony, and that is certainly true in the cases that we have brought. That you have statisticians, you have industrial psychologists, you have econometricians looking at all of these selection procedures to try to evaluate whether, in fact, there is that closeness of fit that the law requires. So, I think that, like any other case, whether it's antitrust or, engineering or anything else, there are hard judgments that have to be made. But when a court is well informed about the competing claims, there's no reason that a court shouldn't be able to do that.
Yeah, go ahead, Alice.
Oh, well, I just want to say something that, on that point, I think it's, I just think Jocelyn gave such a lovely doctrinal answer about how the courts are really careful about policing to make sure you don't go too far with disparate impact, because I think it does go to some of the discomfort in this area that I hear from Kenneth and from others, which is partly about what is the proper role of courts in policing or scrutinizing employment practices. And so I do think it's important to ask those questions. I think at the same time, when I think about the firefighters in New York, I mean, one of the things is the availability of other cities that have done a better job, and why there isn't more learning from those cities. And I think that the political context in New York is part of what informs that. And then I always think about the military, which is so interesting that in the civil rights and race area, that people are always talking about the example of the military. It just seems, like less than a perfect place where you would think you would have an example of social justice or equality. But I think it's an instructive lesson. I mean, some of the things when you said life-saving, technical, I kept thinking about the military and the ways in which that institution, and this has been well studied in the political science sociology literature, about what that institution did to transform itself in ways that made it a more inclusionary institution. So I think for just the broader perspective, not just inside courts and what is the role of courts, which is to be very careful, I think we should also think about what kind of change we want, how do we urge institutions to make those changes, what other examples can we draw on?
I think that's a great transition to the just the concluding points. One being, before disparate impact and Title VII came to job categories like firefighters, the main job criterion was knowing someone on the fire department and looking like you could be a firefighter. And so I think there is, as I began with the notion of, it's upped the professionalism of hiring in all kinds of jobs. The second is, I have to quickly read you the ACS announcement, which is please join us for the closing plenary, free speech, and the Roberts Court, the First Amendment in the first 5 years, which will be in the presidential ballroom immediately following lunch. Volunteers will be on site to help direct you there. And finally, I want to ask you to all join me in thanking a terrific panel.